So you're Jeremiah Branch?
Well, there's 26 DCCR 0958.
1168 is what I don't have.
Yes, I have you right now.
That's the one I'm. He's taking over.
So clause number 25 DCCR 1382. Any evidence with regard to your client's ability to make a bond, or?
Well, Your Honor, I think he's entitled to a bond. I haven't filed a writ to challenge
What
the amount of
happens
the
when
bond.
someone already on probation for robbery is accused of committing multiple new robberies just weeks later? That's exactly the explosive courtroom hearing you're about to witness. In today's case, the judge is faced with a defendant whose criminal history has grown rapidly, raising serious questions about public safety, accountability, and whether he deserves another chance. The defense argues that bond should be granted, pointing to financial hardship, disability, and medical concerns inside the jail. But the prosecution paints a very different picture, claiming the defendant repeatedly violated probation, tested positive for drugs, refused additional testing, and allegedly committed new violent crimes while still under court supervision. As this hearing unfolds, pay close attention to how both sides present their arguments. Notice that this isn't a trial deciding guilt or innocence. Instead, today's focus is whether the defendant should be released on bond while these new allegations move through the legal system. The judge must balance constitutional rights with the responsibility to protect the community, making this one of the most difficult decisions in criminal court. You'll also hear discussion about probation violations, financial ability to post bond, medical issues, and why prosecutors believe the defendant poses an ongoing danger. Every answer given in court has the potential to influence the judge's final ruling. So here's a question for you before we begin. Should someone accused of committing new violent crimes while already on probation receive another opportunity to be released? Or should community safety come first? Let us know your thoughts as we dive into this intense courtroom hearing.
So, Mr. Smith, on Jeremiah Branch, I have a new offense of 26 DCCR 1168. Is there something else coming, or is that?
I think that was the new one, Judge.
I thought there was like
So you're Jeremiah Branch?
Well, there's 26 DCCR 0958 and 26 DCCR 1168 are the two new cases.
I've got Mr. Kimler on one of those new cases, but not the Mr. Kimler.
Not the latest.
Yeah, I don't have.
1168 is the latest one. He was also indicted 3 weeks before that on a aggravated robbery.
1168 is what I don't have.
Yes, I have you right now.
That's the one I'm. He's taking over.
Okay, thank you. All right. So if you'll get a notice filed on that, Mr. Branch is charged with aggravated robbery, assault on a peace officer, robbery, and then the last one is another robbery allegation. And what is the announcement?
He has a bond, I suppose. There's an MTRP.
Have you filed a motion for a bond, or what do you?
We're asking for a bond on the MTRP.
So clause number 25 DCCR 1382, which is an assault on a peace officer, and 25 DCCR 1385, which is a robbery, are both motion to revoke probations. And there are no bonds currently set. Is that correct in those cases? And Mr. Kimler has filed a request that I set a bond in each of those cases. It's like there's been a first amended filed in each of these. So he was placed on probation February 3rd of 2026. In both cases is 10-year deferred probations, and the allegations are a new aggravated robbery from April of 2026, testing positive for cocaine on several occasions, failing to submit to drug or alcohol screening on several occasions, failed to comply with Texas drug education program, a new offense of evading arrest or detention from February 6th, resisting arrest or transportation February 6th. And so, Mr. Kimler, you may proceed.
Well, Your Honor, they're deferred adjudicated probations. We would just request the original MTRP bonds. If the bonds are denied, we would request a disposition on the MTRPs within 20 days of request for the bond pursuant to the code criminal procedure.
Is there any evidence with regard to your client's ability to make a bond, or?
Well, Your Honor, I think he's entitled to a bond. I haven't filed a writ to challenge the amount of the bond because it hasn't been set yet. So I'm waiting for the court to set the bond. If that's excessive, then I would follow.
If I'm going to set a bond, I need to have information on what his ability is so that I don't set one and then we're back in here.
I can elicit that.
Raise your right hand the best you can, please, sir. You swear from the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
All right, go ahead.
Mr. Branch, please inform the court of your current financial situation.
I get $1,000 every month and disability.
And other than that, do you have any income?
I have food stamps, and I was going to look for part-time job too.
What is your disability that prevents you from working?
Seizures, but they told me I could work. I could work like 34 hours a day.
No supplement your.
Yeah.
Do you have any assets? You own your own car?
I don't own my own cars.
Are you undertaking?
My mom gives me up, so I'm not able to give me a ride.
Are they giving you medication at the jail?
Yeah, they just put me on the new medicine, and it's been working good. Everybody on the dorm say I haven't been having seizures or outbursts.
What medication are you on?
I'm trying to get the name of it, but I try to ask my nurse the name of it this morning, but I was sleeping.
Are you functioning okay now?
Yeah, I'm functioning way better now. I haven't. But when I got here, the first booked me in, I had like they definitely in the booking the front booking for like 4 days, and I had like 5 seats in there.
If the judge grants you a bond and you're able to get out, would you follow up maybe as a condition of your probation or a condition of your bond with the HMR?
Yes, sir.
To continue to treatment?
Yes, sir.
And as far as your other financial assets, you don't own your own car, do you rent, or where do you live?
I stay with my mom.
Okay. And your monthly expenses about what are these? As far as food?
She pays the bill, and I'm on food stamp.
Password?
No questions.
This testimony gives us an important look at one of the factors judges consider during bond hearings, the defendant's financial circumstances. Mr. Branch explains that his only steady income comes from disability benefits, that he lives with his mother, owns no significant assets, and has ongoing medical issues involving seizures. Those details can help the court understand whether a particular bond amount would realistically be affordable. But it's equally important to remember that financial hardship alone doesn't determine whether someone receives bond. The judge also has to weigh the seriousness of the charges, the defendant's criminal history, alleged probation violations, and the potential risk to public safety. Medical concerns may influence bond conditions or jail treatment, but they don't automatically outweigh concerns about new violent allegations. What do you think? Should a defendant's medical condition and limited finances carry significant weight in a bond decision, or should the nature of the alleged crimes remain the deciding factor?
No questions, Judge.
It's for the record, I'm taking judicial notice of the court's files in all of the cases. And so give me just a second. I'm right now going over the probable cause affidavits and those 2 new offenses. Then I'm going to get to something else as well. Any witnesses, Mr. Smith, or just argument?
Just argument.
All right, give me just a second then. So there was already information when he was placed on probation in January with regard to some mental health issues, and that was addressed. So he was placed on the mental health caseload. So it looks like that's not a new information, that he had some. Okay, Mr. Smith.
Judge, I understand that these are deferred cases, but the state is opposed to setting bond based on the nature of the crimes that he was on probation for and the nature of the crimes that he committed within 2 months of being placed on probation for these first robberies. on top of the two felonies that are filed, there's also evading and resisting that are pending in misdemeanor court. He has failed several drug tests. He's refused to take other drug tests, indicating to me that he is probably under the influence of illegal narcotics most of the time. And for those reasons, I believe he is a danger to our community, and I would request no bond in these cases.
I would just
Now the
add,
hearing reaches its most critical point. After reviewing the court files and listening to both sides, the judge has to decide whether releasing Mr. Branch would create an unacceptable risk. The prosecution argues that this isn't an isolated incident. According to the state, the defendant was already on deferred probation for serious offenses when these new robbery allegations surfaced, alongside alleged drug-related probation violations and additional pending charges. From a legal perspective, prosecutors are asking the court to focus on patterns of behavior, not simply one allegation. Their argument is that repeated accusations occurring so soon after probation suggest that previous supervision hasn't prevented further criminal conduct. The defense, on the other hand, continues to emphasize the defendant's legal right to seek bond. This is where judicial discretion becomes incredibly important. Every decision must balance the defendant's rights with the safety of the public. If you were sitting in the judge's chair, would you approve bond under these circumstances, or deny release altogether?
I would just add, Your Honor, if the court refuses to set a bond requesting us disposition within 20 days of the MTRPs.
So here's what I'm going to do, Mr. Branch. So the underlying offense that you're on probation for is a robbery and an assault on a peace officer. And the robbery occurred at Delaware Food Mart, went in, attempting to steal, assaulted the clerk, and then they held you there while the police got there. And here we are 2 months after you got placed on probation, or 3 months after you got placed on probation for a robbery of a store. And we've got 2 additional robberies of the same store 3 days apart that are alleged. So obviously I agree with Mr. Smith. I think that you are a danger to our society. I am going to set bonds. I'm going to set bonds in each of your cases at $300,000. Conditions of those bonds, if you make them, are that you are on house arrest with a GPS monitoring device, and then we'll set your case for the appropriate hearing. Right.
Thank you.
Thank you.
The judge's explanation makes it clear how this decision was reached. Rather than focusing on just one allegation, the court looked at the broader timeline presented during the hearing. According to the judge, the defendant had recently been placed on probation for robbery-related offenses before facing allegations of additional robberies involving the same store only a short time later. From the court's perspective, that sequence raised significant concerns about community safety. Even though the judge concluded that the defendant presented a danger, notice that bond was not completely denied. Instead, the court imposed very high bond amounts along with strict release conditions, including house arrest and GPS monitoring if bond is posted. This reflects a balance between recognizing the defendant's legal right to bond in these proceedings, while also attempting to reduce potential risks if released. Do you believe this was the right compromise, or should the court have taken a different approach? Share your opinion in the comments below.
Thank you.
This hearing demonstrates just how complex bond decisions can be in criminal court. The judge considered multiple factors, including the defendant's financial circumstances, medical testimony, probation status, criminal history, and the seriousness of the new allegations presented by the prosecution. After weighing those competing arguments, the court ultimately set $300,000 bonds on each case, along with strict conditions requiring house arrest and GPS monitoring if the defendant is released. It's important to remember that today's hearing did not determine guilt or innocence. The purpose was solely to decide the conditions of release while the criminal cases continue through the justice system. The underlying charges will still have to be resolved through the normal legal process. Cases like this often spark strong opinions because they involve the difficult balance between protecting the public and preserving the legal rights of individuals awaiting trial. Where do you stand on the judge's decision? Was the bond amount fair, too lenient, or too strict? If you found this courtroom breakdown informative, don't forget to hit the like button, subscribe for more real courtroom analysis, and share this video with others who enjoy legal case breakdowns. Your support helps us continue bringing you the most compelling courtroom moments and professional legal commentary. We'll see you in the next case.